It's my great pleasure to welcome all of you to this year's Bergen Exchanges on Law and Social Transformation here at Bergen Global. It is a special year. I think we had all thought and anticipated and hoped that we could do what we normally do, to invite lots of colleagues and friends from across the world, pack the auditoriums to capacity. But of course, we all know that even this year, we have to do it differently. But we have learned how to make digital formats work and to make hybrid formats work. And that's what we're doing this year. And we are actually really lucky because we have a nice and not too small, and actually to capacity and more audience here at Bergen Global. And it is wonderful to be able to actually also welcome some people from abroad for this event. So it is a true Bergen Exchanges, where we will, for the coming week, discuss issues of how law is mobilized and used, how we can research law, what the effects of law and courts actions are across the world. We will present many different research projects, some ideas that might become research projects, and we will have a range of practitioners, but mainly scholars from across Norway, across Europe, and digitally also across the world. So if you're in Bergen, keep coming to the events. If you're online across the world, keep logging in to this stream, which will be there for the whole week. My name is Siri Gloppen. I'm the director of LawTransform, the Center on Law and Social Transformation, which is one of the organizations hosting the Bergen Exchanges. This year, we have a large number of partners and co-hosts, and you will meet some of the directors of the partner organizations just now. Because the three main partners this year is the law school at the University of Bergen. The University of Bergen is one of our owners of LawTransform. It is CMI, which is our other owner, because of Michelsen Institute, which is in this building. And it is the Center for Research on Discretion and Paternalism, which is our main partner for this Bergen Exchanges this year. And as you see, child rights, if you look at the program, child rights is a big topic this year. And DIPA, which is, we call it for short, have been key in organizing almost all of the child rights events. Our other main topic this year is autocratization dynamics, the way in which law is being used to undermine the rule of law and democracy across the world in different ways. It is also issues around law and inequality, how law is either used to address inequalities or creates inequalities in gender and in health in particular. So these are some of the issues that we will discuss. And the first person to welcome you will be the Dean of the School of Law, Karl Harald Søvig.
Thank you, Siri, and thanks for the nice introduction. And welcome to this year's event. Law and society is extremely fascinating. This interplay and interrelation, and of course we can discuss this and analyze this for hours. At this year's program, there are only some topics on the agenda, but I think it's interesting, and I look forward to participate, and I will also be on one of the events. First of all, it is important for the society to understand law, and as a lawyer, I often feel that the society and others does not fully understand how important law is as a kind of regulatory framework in the modern society. We use law to organize the society, and of course there are lots of deficits when it comes to law. For example, taxation is very fascinating to see how this has changed in the last decades, where major companies hardly pay tax at all because they are not trading with goods anymore, but the kind of services that are very difficult to tax, and they are very easy to move. This year, of course, COVID is still a kind of hurdle, but we can organize this also with COVID, and thanks to Siri for all your efforts. It's a lot of more work for the organizers when you have both physical and digital events. So thank you very much for all your efforts, Siri. Last year at the opening, there was also some remarks regarding COVID, and a legal historian reminded us that COVID, it's important that we have had pandemics during the last, not only decades, but for many thousand years. And during one of the last pandemics for about 200 years ago, it was a regulation. And that was that if you, on the border between Norway and Sweden, if there were persons coming from Swedes, you were allowed and even obliged to shoot them. Of course, that's a hard measure. I will not suggest that we should introduce it, but it reminds us how legal regulations has been important throughout the centuries to combat, or at least be a part of the combat of pandemics. At this year's program is the rule of law, and as Siri mentioned, it's important to, even though human rights and so on is used to build rule of law, we can also use law or legislation as part to kind of build down or to limit the rule of law. Look to Poland, when there has been this discussions about independence of judges in Poland. One of the tools that has been used from the government is to introduce new rules concerning retirement age. So it is important that law is an important tool also for those who want to interfere or diminish the importance of rule of law. But it's important that this is not only affecting other countries. We will have a discussion later on about the European Court of Human Rights and its impact in Norwegian child protection law. And it's important that rule of law is not only for other countries, it is also an ongoing discussion within our own country. So I think we have a lot to discuss, but I don't think that I should make the discussions now. I think we should have them with a panel and so on. So I would just say, once again, thank you, Siri, for all your efforts, and I really look forward to this week.
Thank you so much. Before I give the words to the next speaker, I just want to say thank you, but we are such a great team getting this into place. And there are so many people working literally day and night, particularly for the last week, both at LawTransform and at DIPA, to make this happen. And I just really want you to know that it is so much appreciated, and that there are so many volunteer efforts and hours that go into making this happen also this year. So thanks a lot for reminding me. But then I want to introduce our second host institution, or owning it, the second institution that hosts LawTransform and the Bergen Exchanges, Ottar Mæstad, who's the director of CMI, of the Michelsen Institute. Please.
Thank you, Siri. I'm really pleased to welcome you on behalf of CMI to yet another years of Bergen Exchanges. It's actually now the 8th year in a row of these conferences, and it's a fantastic privilege as a director to have such a dynamic research center here in Bergen at CMI and the UIB that host these conferences every year. Looking at the program, I find it really impressive. It's impressive in terms of the scope. 20 events now in the coming 5 days. It's impressive list of contributors from around the world. Fantastic scholars from from Bergen, from many different countries. You have really a lot to look forward to. I think the program is also, or the center or Bergen Exchanges in general is very impressive in terms of the breadth of the topics that you address. You have already heard Siri mention the main topics this year: child rights, on autocratization, on health inequalities and gender inequalities. And one of the really fine things I think about Bergen Exchanges is your ability to be inclusive, capture a lot of topics, and discuss them in light of long-term research interest, but still combine them with very timely discussions about things that are happening right now. And in this year, I think you have been even more timely than you dare to think about when you plan the program. I'm thinking, of course, about the serious developments in Afghanistan the last few days, and the fact that you have this on the agenda this year and discussing women's situation in Afghanistan. Really important topic. But that's only one thing. There's lots of other things that is both interesting and timely. It's sad, of course, that many of you cannot be here. Even those who could be physically present here, some of you was not allowed to come here because we cannot host that many people in this location. Because Bergen Exchanges is very much a social event. It's everything that happens in between the seminars. That is very much the heart of Bergen Exchanges. But still, we are happy that this year we have more people here than we had last year, so it's an improvement. And Siri said it's actually 14 nationalities represented here, either physically on stage or in the auditorium. Organizers. That's really impressive, I'd say. I also say thanks to the center for not only for hosting this event, but being such a dynamic force throughout the year, and putting Bergen on the map as a hub for discussions on law and social change. And I also want to say thanks to all the volunteers. It would not be possible without you, as Siri already mentioned, really important. The center has been run by a lot of volunteers, plus Siri and a few others for many years. But I'm happy that now we have also taken some steps to improve the more permanent structure around the center. Lara Cortes has become the coordinator. She'll come forward. Yes. Okay. You're here. And then Liv also can come. Yes, because yeah, Lara, you are the new coordinator of the center, and Liv is the new co-director of the center, together, I guess, with Malcolm still, and with Malcolm is going over in a new role, and I'll come to that in a moment. I'm not fully updated, sorry. But what is very good, what I'm very happy about is that Siri still can continue as the director of the center, despite also being a vice dean now for the coming 5 years. You also go up. We do it now. I do it now.
No, much less. Actually, a pauper.
No. So maybe I can. Yeah, so Malcolm, of course, has been the partner in crime, as co-director of the center since long before we started, actually, and it has been wonderful. Always a great inspiration at the exchanges, both intellectually, socially, and everywhere. And I'm very happy that you promised to continue and continue to come, I hope, but as an advisor more than a co-director, because we've got so many hats together. So I wanted to just actually give you some wine, but this is wine, but in a good way. And also, you can't carry them so far, but I also wanted to give you some of the flowers.
Oh, beautiful.
And I actually want to give you I'm turning the other one. This has been amazing. There is only one Malcolm. At least only one Malcolm Lamford at LawTransform, and you're very special, and we really love you very much. and we want to keep you close. But thank you for your efforts so far, and looking forward to your advice also in the future. And Liv, it is amazing and wonderful that you actually accepted to come in as co-director. So thanks a lot.
Thank you. I'm looking forward.
Actually, I wanted to say thank you to some other people as well. In particular, the co-organizers of the event. It's a great pleasure for us to have so many willing collaborators around the city. We have Deepa here, of course, but there are others as well. It's Rafto Foundation, it's GRIP, it's BeEx, it's Center on Humanitarian Studies, and maybe more.
It's Bergen School of Global Studies and Bergen Global.
And Bergen Global, you know, so many. Really wonderful that we come together and make this event such a much richer event by combining forces like that. With that, I just wish you a fantastic week.
Yes.
A lot to look forward to, and good luck. Thank you.
Thank you so much, Ottar. And I must say, you've been here and part of every opening since we started in 2014. And it has been wonderful. You always lift our spirits. But it might be the last time because your term is in my direct plan.
Yes.
And so, but you must promise you'll still come to the Bergen Exchanges.
Make a promise.
It won't happen without you. So thanks a lot. The last but not least, I want to give the word to the main partner for this year's Bergen Exchanges and always wonderful colleague, Michelsen, Director of DEPA.
Thank you. Thank you, everyone. Wonderful to be here today together with you all. And thank you so much for coming to Bergen Exchanges 21. I'm the head of the Child Rights Unit at LawTransform and also then the director, as Siri has introduced me. Children's Rights is one of the pillars at Bergen Exchanges. And this is a team that is very important, and it's important because it concerns enormously many people. Also, it is very, very important to enlighten that we have huge knowledge gaps on this important team, surprisingly huge knowledge gaps. Around 28% of the population in the world are children. And in some countries, half of the population are under the age of 18 years old. Just imagine that. The Convention on the Rights of the Child of 1989 is ratified by almost all countries in the world, except the USA, and the USA do subscribe to its principles. The core principle of the Convention is the right to health and life, it's the right to non-discrimination, it's the right to participation, and it's the right to having the child's best interest as a primary concern. These core rights seems obvious and easy to implement. Of course, right to life. Of course, you should have a life without discrimination. Of course, you should have a say about your own life and what matters for you. And of course, your best interests should be taken care of. However, as we will learn throughout Bergen Exchanges, countries differ enormously in how they do protect children's rights and how they respect children's rights. Some because they don't have the ability, some because they don't have the will. The Convention's principles are also ambiguous and they may be conflicting. Just imagine children's right to participate and to make decisions that matter in their lives. How is this compatible with the fact that children are still growing up? They are still about to develop their competencies and their capacities. Will children make decisions that are in their best interests? We also observe that children's rights disturb the traditional relationship between the state and the family. The state now has an independent responsibility to protect children's rights. But that also means that they have to protect them if it is against the parental rights. And in some situations, this creates huge conflicts and it challenges our traditional concept and our traditional institution, the family. In some countries, we see a strong pushback with increased focus on traditional family values and rejections of children's individual rights, also together with women's rights and also other individuals' rights. The coming week, we have some really great speakers and discussants that will teach us more about children's rights and the ongoing controversies. I wish you all a good Bergen Exchanges week. And I give the word to Siri again. Thank you, Siri.
Thank you so much, Marit. And thank you for this great introduction to the topics of this year's Bergen Exchanges. And it is important also to see how things are connected. And I think that what you've been talking about when it comes to the increasing contestation of rights is something that is going to be a theme that we'll talk a lot about across. That there are a lot of rights that are currently under pressure in different ways. So in many ways, I think that's going to be one of our concerns. And it is, of course, a concern for the human rights community. It is this pressure that there has been and is over the rights that we thought were quite well established and well founded. Whether it comes to some of the things that we're not focusing particularly on this year, but also migrant rights. So that is really, really under pressure, and asylum rights. And also, as we're going to see in the first panel very soon, women's rights that has been sort of, we thought were well established, that are also very much under pressure. So that is sort of the serious note that I think we'll bring with us across the 5 days. But of course, we're also going to think about how that can be mobilized against, and how we can sort of use how different actors are using rights as a force for protection and as a force for democracy. I wanted to also focus on one last thing before we start the first panel, and that is that the Bergen Exchanges is also a PhD course. And this year, we've had 2 weeks already of the PhD course. And we have 25 students from across the world who are participating digitally in the Bergen Exchanges as part of their PhD course, and some also physically. So some are here at the opening today, and some will be joining us for many of the sessions. And that's also something that we do every year. And it is one of the things that really, really makes the Bergen Exchanges so vibrant. It is that we have these young scholars who are engaging with all of these topics as part of their training, but also engaging with us who have been in the game for a long time, and students who come, and practitioners. So we have this cross-disciplinary, international, and cross-generational exchange, which makes, for us, the Bergen Exchanges so important and makes us so grateful that you all are participating. With that, I think I will let Marit and Ottar go now.
Okay, thank you so much.
So thanks a lot. So our first session today focuses on exactly the backlash that we have been seeing recently against the rights of women's rights, but also rights related to gender, more generally. Gender ideology as something to be contested, women's rights, the rights of the family as something to be given primacy, is something that we're seeing in many countries across the world. And in the coming hour and a half, we will have different perspectives and viewpoints on that. We're extremely lucky, and I'm very, very grateful to welcome Ruth Rubio Marin, who is a great friend of me personally, of the Bergen Exchanges and the line of LawTransform, and a great, great scholar on the topic to give the first keynote at the Bergen Exchanges this year. And Ruth she's a full professor of constitutional law at the University of Sevilla in Spain. She's also at the University of Andalusia, the International University of Andalusia. She is the UNESCO chair for human rights and
Interculturalism.
interculturalism. I'm sorry. Ruth also still holds a position at the European University Institute in Florence, and is also a member of the faculty at the Hauser School at New York University. So, and a member of us, and at LawTransform. So we are extremely grateful that you are coming to share your knowledge. And of course, Ruth has published a lot, books, articles, and also just finished last week another book sent to the publisher. So a very active scholar, very knowledgeable, and it's wonderful to be able to welcome you to give this keynote. So Ruth.
Thank you, Siri. So thank you, Siri. It is an honor to be here. I have to say that in spite of the many institutional hats that you have mentioned, this is the only forum in terms of conferences that I have been loyal to in my life, because I think it is the most vibrant, the most fun, the most engaging, the most interesting, the most compassionate, and the most creative. So bravo to you all, and to all of those institutions that make this possible. Long live the Bergen Exchanges in spite of COVID. And having said that, I'm really glad that Norway changed its policy about pandemics and foreigners crossing borders. So today I'm going to be discussing with you the global backlash against women's rights. There is going to be a panel, as you know, with excellent participants who couldn't make it physically, but I was asked to give a keynote on the subject. And what I thought I would do is, if I can figure this out, okay, is basically lay out the general features of this anti-gender equality movement. Then maybe, because I am a constitutional scholar, flag out some of the constitutional tactics of the lawfare around which, or through which, this resistance and this backlash is being articulated. And then finally close up by raising really two questions to which I don't have an answer, but I'm kind of a positive personality. It's my DNA. And so I do want to ask ourselves, is there any way in which we can look at what is going on as an opportunity structure and not just as something fearful and threatening, which it is. So I think that if we ask ourselves, what is at stake, then I think that we really should acknowledge that we have been witnessing a true gender war of constitutional dimension, with thousands of citizens around the world taken to the streets to either celebrate or protest against new, aspired, or achieved milestones in the conquest of the rights of women, but also sexual minorities. So I think, and let me foreground this, that to a large extent, I believe this anti-gender equality movement is but a reaction against the true gender revolution, seeking the disestablishment of the traditional gender order and gender roles since the conception of the modern order built around the traditional family. So if you look at the slide that I'm sharing with you, it's the Suffragette March, New York, May 3rd, 1913. And then you look at this other slide, you can see what has happened in only a century. This is women asking for power, and what they meant was suffrage rights. And just a century afterwards, you have images of Kenyan women and Indian women in different ways in 2019 asking for parity of representation. The voting rights is really not sufficient. And that just in 100 years. So I think that, what is going on, and I'm showing these two slides that come to help us visualize the dimension of the revolution in 100 years and what is really at stake. Here is a postcard of the National League for Opposing Women's Suffrage campaign publicity in the UK. After a hard day's work, here's the woman who has neglected her home duties and her child because she has been mobilizing for suffrage. Some more images about the extent to which already then it was perceived that women's political empowerment was a threat to gender roles and to the traditional construction of the family order. And this is really what is at stake still today, which I think is fascinating. So as with every major challenge to dominant norms justifying the legitimacy of existing power structures in the history of political thought, resistance to the disestablishment of patriarchy and its underlying gender order, I think, was to be expected and has arrived. I mean, just think of the defeat of the monarchy, or think of the challenge of religious establishment for the sake of secularism. None of this happened without resistance or backlash. Why would we expect that patriarchy as a political form would simply die without resistance? If we ask ourselves about the roots of this, then we need to recognize that these neoconservative reactions by what is become now an organized transnational and increasingly global phenomenon appeared already in the late 90s in several European countries and elsewhere, particularly in Latin America. And they built on the pre-existing infrastructure of earlier anti-abortion groups in the United States. And they appeared in the late 90s precisely in response to international developments. I'm referring to the International Conference on Population and Development, Cairo Conference, 94. And of course, I'm referring to Beijing, the Conference of Women in Beijing in 95, all of which foregrounded women's empowerment, sexual and reproductive rights, and gender as a relevant category of analysis for the purpose of understanding the proper nature and dimension of violence against women as a form of gender subordination. These major international conferences gained relevance on the agenda of international and regional organizations such as the UN, the European Union, Council of Europe, Organization of American States, and they triggered in turn a defensive affirmation already expressed during these international conferences by the Vatican, the Christian American Rite, as well as various other states from Christian and Muslim traditions. So this anti-gender discourse was indeed fostered by the Vatican between the mid-90s and the mid-2000s through a process of building a counter narrative, which is said to have culminated with the publication of the famous Lexicon of Ambiguous and Debatable Terms regarding family life and ethical questions in 2003, contesting of about 100 articles on sexuality and bioethics written over 70 different authors. This was the counter narrative, the intelligentsia to back the advances that were being made. It was only later socialized for the purpose of mobilizing wider constituency that became particularly active since 2010, relying on an increasingly sophisticated funding schemes, which I'm sure Neil Datta, who is with us today, will describe as he has been the main author of Tip of the Iceberg, this fascinating report that tells us how religious extremist funders have been organizing to back this counter mobilization. So what is a more recent phenomenon is the permeation of these counter narratives into civil society and the addition of new actors in the battle, as well as, I would say, its degree of politicization. That is a phenomenon of the last decade and one which has relied on several actors. If we think for a moment of these actors, well, we have that there are many. It's a complex constellation in each country. There is, of course, variation, but they typically include family associations, men's rights associations, anti-abortion groups, religious conservatives, conservative think tanks, nationalists and populists, mostly, but not only right-wing, far-right groups and Catholic leaders, even though the Catholic Church was not the only religious organization behind it. And in fact, we know that there have been fruitful coalitions between Catholics and evangelicals, Pentecostals and other Protestants, but also Muslims and Jews and other religious groups in various countries. Now, what is interesting also is to notice the various narratives and discourses that are displayed against gender ideology, that these actors, and the way in which these discourses resonate strongly with several of the ongoing debates in Western societies, including national and racial anxieties and resistance to globalization. National and racial concerns are sometimes also connected to demographic anxieties, particularly strong in Russia and parts of Eastern Europe, which has also gained traction in the United States among white supremacist demographic fears as they see a white and Christian civilization under threat. They clearly resonate with the church's foretelling of an anthropological revolution leading to the self-destruction of humanity unless a new human ecology comes to its rescue, a narrative that has obvious links to the challenges around environmental issues. Resistance to globalization fuels the return to the national in many European societies that several populist and far-right forces are agitating, often with an explicit anti-gender, anti-feminist, anti-immigration, and homo-transphobic component. So this is taking place in a context in which, citing Pujar and Paternotte, claims to sovereignty, authenticity, tradition, you were mentioning that before, and these notions are raised against supranational diktats and the uniformization resulting from globalization. This is the narrative. An international organization led by cosmopolitan elites and left-wing intellectuals like ourselves, I guess, are said to be imposing in a new form of totalitarian indoctrination. This is the claim, we are the enemy. A certain narrative of post-colonialism is especially dominant in the African continent, where in spite of some celebrated progressive milestones, the criminalization of abortion and homosexuality unfortunately remains the norm, and where Christianity is fast expanding thanks in part to American support and funding. And the Catholic Church has explicitly accused gender movements and the agencies promoting gender awareness of coercively imposing via funding a gender ideology in the global South. Islamic conservative forces, including but not limited to those backed by political Islam, also react against the supposed imposition of Western values, which they see as contrary to the traditional Sharia-inspired Muslim family, foregrounding the complementarity of gender roles. So you see, the constellation of actors and narratives. So we have seen what is at stake. We have discussed briefly, what are the roots and the actors and supporting narratives of these movements. You have an image of Manif pour tous, one big manifestation that took place in June 2013 in Paris against same-sex marriage, just to render vivid, the extent, the scope, and the modalities. And I'm now going to turn to the constitutional tactics and focus on the constitutional dimension of the lawfare that is surrounding this counter-mobilization. And I'm happy to present to you the cover of my upcoming book, Global Gender Constitutionalism and Women's Citizenship, and in which I develop in more detail these arguments that I will briefly summarize for you today. So I have listed 4 different constitutional tactics. Indeed, we find that over the last decade, we find manifestations of anti-gender equality through shared tactics and varied tactics. They include rallies, mobilization platforms, and colorful events, sit-ins, protests, and narratives of self-victimization that support the depiction of dissidents of gender ideology as a threatened minority. They are threatened, displaying also an imagery of childhood that underscores children as paradigmatic vulnerable victims. Now, this form of mobilization has been seen to take place in reaction against various concrete policies. You have the example that I showed you in the French Manif pour tous regarding fighting against the introduction of same-sex marriage, under banners that included some like "We want sex, not gender," and "Do not touch our gender stereotypes." But it has not only effective legislative agendas, but also presidential campaigns, and even the signing of peace treaties in some Latin American countries like Colombia, where its gender-sensitive Havana Peace Agreement for grounding women's participation and interests was accused of secretly importing the gender ideology, which would be destructive of the family. So, although in many contexts, the arguments and the fight is against proposed initiatives, in many other contexts, the fight operates preemptively. There isn't a concrete proposal that is being discussed. What there is movements that are taking place internationally and regionally, and actors preemptively acting so as to prevent those changes from taking hold at home. But as I say, much of the energies have been geared towards constitutional law first specifically. And my contention is that this is because the constitutional level has the advantage of offering a secular language and being, in a way, a natural domain to discuss fundamental rights, and thus to counter pro-women's equality human rights discourses, while at the same time for grounding the notion of the national constitutional identity, as opposed to the cosmopolitan or the international visions, which are being imported foreign impositions. And what we see is that various actors, both bottom-up and top-down, have seized the constitutional framework of rights, but also of constitutional identity as battlefields in a reaction that we then find some courts accepting and others resisting. And in essence, the change in discourse, grammar, and activism now allows to escape the traditional opposition between the religious and the secular, insofar as it takes advantage of democratic mechanisms and secular arguments to position its demands. So it's not secularism versus religion. We disguise this all in constitutional parlance, and so it's really a secular, purportedly secular reading of the contended issues. This tactic allows its functioning in increasingly secularized societies on the one hand, but also the formation of coalitions with nationalist political forces and populist governments that do not necessarily have a religious profile. Think of Hungary. So let me briefly discuss the various constitutional tactics. In the first one I would like to mention is constitutional entrenchment. So, and this is a tactic that consists on entrenching a certain vision in the Constitution, typically through constitutional amendment. And I would say that the best example of this may be the dynamics that since the last date have taken place in the Arab world. In countries like Egypt or Tunisia, Islamic forces coming to power, thanks in part to the Arab Spring protests for democratization and social justice, threaten to further curtail rather than expand women's rights. Electorally won majorities are sought to constitutionally entrench a vision of gender relations based on the notion of complementarity following the dictates of Sharia law. Yet similar dynamics have also developed in the Christian world, where the constitution ban or discriminatory treatment of same-sex marriage and same-sex unions in Central and Eastern Europe has probably become the most widely shared expression, although the targets of these movements seeking the reaffirmation of the traditional family, as we know, also include abortion and other reproductive rights, sex education, and trans rights. Now, to understand the roots of the phenomenon in Central and Eastern European countries, it must be taken into account that in post-socialist regimes, the church has often, not always, think of Poland and Croatia as cases where this is the case versus Hungary, but in these countries, the church has often been identified as one of its victims and of the socialist era, and the church has been traditionally considered a repository of national identity. So what we see is that since the early 1990s, the church has tried to restore its previous role of moral authority, whether through civil society or directly through governmental collaboration, by means of a process of retraditionalization of society. Also, in post-socialist Europe and Russia, the claim is made that gender ideologies represent a new form of totalitarianism equated with neo-Marxism, a form of value imperialism advanced by international and regional organizations and academic elites, which are anti-democratic in character. In terms of constitutional dynamics, we can, however, distinguish countries like Hungary and Poland, where the ruling parties are the one leading the movement by taking advantage of their parliamentary majorities, as in Hungary, or of their increasingly government-packed courts, as in Poland, from others in which the process of constitutional entrenchment has followed a rather bottom-up dynamic with civil society actors and church actors taking the lead role. Constitutional entrenchment has proven particularly useful in Hungary, with the Constitutional Court trying to resist the complete subversion of liberal and egalitarian values that in more or less decisive manner it had tried to protect since the transition after the fall of the wall. The coming into power of Viktor Orban's populist movement in 2010 brought about the rejection of a culturally liberal agenda embraced by most of civil society and the reform of school curricula, and gave the right-wing Fidesz coalition government the two-thirds majority it needed to change the constitution. So the new 2011 Hungarian constitution now proclaims human life to be protected from the moment of conception. It defines marriage as the basis of the nation's survival and as a conjugal union between a man and a woman. It also provides that Hungary shall encourage the commitment to have children. When in 2012, and partly relying on case law by the European Court of Human Rights, the Hungarian Constitutional Court struck down certain legislation that really proposed a very, very narrow conception of the family, then the majoritarian forces in power responded by simply passing a constitutional amendment in 2013 that entrenched the privileged position of heterosexual and procreative families, while also limiting the review powers of the court itself. This move was then followed by an opposition to European norms in support of sexual and reproductive rights, and by a rejection of European anti-homophobic agendas. And we see news around this every day in the papers. They have been accompanied by calls on Hungarian women to have more Hungarian children and by the advocacy of family-friendly policies and services. Now, if Hungary represents an example of the supermajority in office trying to surpass constitutional limitations on its illiberal policies by way of constitutional amendment, Poland offers an example of a country in which restrictive interpretations by the Constitutional Court, whose judicial independence, as we all know, is increasingly called into question, have also been relied on to constitutionally entrench the Catholic identity and tradition of the country against both its communist past and the liberalizing trends taking place in Europe. And although its 1997 constitution was only reformed in 2009 to entrench heterosexual marriage, the Constitutional Court had already endorsed the heterosexual nature of marriage, and in 2005 and later decisions, the 2005 was specifically linked to the EU Treaty of Accession. And even though proposed legislation in 2016 severely curtailing abortion rights, which bishops and lay Catholic groups had pressured the governing Law and Justice ruling party into passing, even though this proposed legislation in 2016 failed thanks to massive street mobilizations that we all witnessed, the Constitutional Court, as you may know, handed down a decision in 2020 banning abortion in the case of severe fetal malformations, which are said to account in Poland, a Catholic country, for about 98% of all terminations carried out in Poland, so practically banning abortion in Poland. Now, if top-down exercises of constitutional amendment, whether through majoritarian dynamics as in Hungary or governmental pact courts as in Poland, they're not the only ones taking place in the region, and conservative forces in civil society, as I mentioned, have also accounted for several of the multiple constitutional amendments to resist the constitutional disestablishment of the traditional family, and for several of the referendum campaigns, with or without success. These referendum campaigns have accompanied such reform processes. I'm referring to those in Croatia in 2013 that was successful, or those in Slovakia 2014 or Romania 2018, the last two of which were not successful, but only due to low voter turnout. The second constitutional tactic I want to mention is constitutional erosion. So basically here, the tactic is not to change the constitution, but to narrow down or overturn through judicial interpretation certain precedents so as to limit previously recognized rights in favor of women and sexual minorities. And I think the earliest expression of constitutional erosion as a tactic is provided by the ongoing, still today, very much today, warfare against abortion rights in the United States. In fact, this constitutional warfare is very old, given that already in the years after Roe v. Wade, pro-life advocates organized against its doctrine, including at times through clinic violence. And while in the 70s and 80s, many focused their energies into the passage of the Human Life Amendment seeking constitutional entrenchment, that failed. And so they then, at the turn of the century, turned to a more incremental strategy, seeking not to ban abortion, but to gradually erode it through increasing regulation. This regulation came to focus less, in theory, on the protection of the fetus and more on the supposed protection of women from the harms of abortion and the greed of abortion providers. And this was, as I said, intended to hollow out the constitutional precedents, even without the court overturning it explicitly. Now, this trend towards tighter restriction on abortion accelerated dramatically in the wake of the 2010 midterm elections, which, as you know, brought the Tea Party and other conservative candidates into office, for whom ending abortion was almost an existential priority. And so you see that all over the country, laws were passed regulating abortion. In 2011, there were only that year, there were more laws passed regulating abortion than in any other year in American history. Supporting this legislative frenzy was the influential pro-life advocacy group, Americans United for Life, a group that was founded in 1971 in response to the liberalization of abortion laws at state level at that time. But it has also supported anti-abortion struggles in many other parts of the world. Its activities included drafting model legislation, such as those known as TRAP laws, Targeted Regulation of Abortion Providers, TRAP, singling out abortion providers and imposing burdens on them different from and much more severe than those imposed on providers of other healthcare services of comparable risks, with a very explicit intention of driving abortion providers out of business under the pretense of protecting women. So what we have to say is that so far the core of Roe v. Wade and Planned Parenthood and women's abortion right until the point of viability has been preserved by the Supreme Court, yet the court's recent shift to the right following the appointments of conservative justices in the Trump era has been said to give, AUL and other pro-life advocates every reason to persist in their campaign to restrict abortion rights. And whether they will succeed or not, I think we're likely to find out very soon. Dobbs versus Jackson Women's Health Organization is a pending US Supreme Court case dealing with the constitutionality of a 2018 Mississippi state law that bans abortion operations after the first 15 weeks of pregnancy. Lower courts have ruled in preliminary injunctions to prevent the enforcement of the law on the basis that it violates the holding of Roe v. Wade. which, as I said, generally allows a woman to opt for abortion in the first 24 weeks, viability being a crucial moment. And that case is expected to be heard, still in the ongoing 21-22 Supreme Court term. Please notice that at least 22 states with Republican leadership had passed or were in the process of passing strong anti-abortion bills when the current case in the process of the Supreme Court, when the current case was certified by the Supreme Court in May 21, with the intent that these bills would likely be met with lawsuits as they are being met, and that serve as legal vehicles to bring a challenge to Roe v. Wade to the Supreme Court, with the expectation that the new composition of the court will finally strike down the constitutional precedent. The third tactic that I would like to mention is that of constitutional co-option. And this tactic also targets constitutional or uses constitutional interpretation. Yet here, instead of seeking the erosion by abolishing or altering the contours of rights of women and sexual minorities, this strategy relies on the appropriation of constitutional rights discourse, which calls on rights provisions to protect not minority or oppressed people's rights, as we would expect from fundamental rights, but to protect majority values against their perceived erosion. So in essence, constitutional co-option results from a combination of a subversion of the constitutional logic of fundamental rights, typically not expected to protect majorities, but minorities, and the supraordination of religious and or ideological freedom. In essence, the strategy then consists on seeking constitutional accommodation of far-reaching conscience protections through exemptions, whether legally articulated or judicially won, which can significantly erode the rights of women and sexual minorities. And in recent years, this tactic is seeing the light of the day through legislation seeking the banning of gender and sexuality teachings at school or from academic curricula. I know we are going to be discussing this very issue in some other of the sessions in the exchanges on the alleged basis that these gender teachings constitute ideological indoctrination and therefore violate freedom of conscience, freedom of thought rights that are in the Constitution. And this legislation is being constitutionally contested both in Latin America and in Europe. And I will not say more about constitutional co-option because Professor Reva Siegal, who is one of the speakers in the roundtable, has written extensively about this issue, and I'm sure she will expand on it. So finally, one last constitutional tactic, which is the constitutional tactic of preemption. And this tactic basically affirms the priority of the Constitution against international human rights law. And I would say it is best exemplified with the ongoing debates around the constitutional validity of the Istanbul Convention, the Council of Europe's Convention on Preventing and Combating Violence Against Women and Domestic Violence in Central and Eastern Europe. This tactic then consists of reading a constitutional essence out of the national constitution, which is framed in constitutional, national, traditional identity terms, and articulating the claim that the constitutional core must trump over the international norms, and whether or not, it has been ratified and has led to so this discord has led to non-ratification in some countries. I'm talking of Bulgaria and Hungary, but even to backtracking in countries which had already ratified the convention and now feel that they must rectify. I think the best example is Turkey's unilateral withdrawal under Erdogan via a governmental decree that is now constitutional challenge. But we could also mention Poland, which hasn't quite yet withdrawn, but in July of 2020, the Polish Prime Minister brought a petition before the Constitutional Court to review the compatibility of the Istanbul Convention with the Polish Constitution, calling for a rejection of the Convention's ideological background, ideological content, and the specifically promoted worldview as against traditional and constitutional understandings in Poland. Many of the common features of conservative opposition to gender violence legislation and actions in general, and to the Istanbul Convention in particular, include indeed several claims of constitutional dimension, and they will resonate with you, such as, just to name a few, interference with family privacy. I'm pointing at you because you raised that argument just a minute ago. Sex-based discrimination against men who are said to be victims of domestic violence just as often as women, and the various due process rights of male defendants, which might be undermined, or religious freedom. But these separate arguments, beyond these separate arguments, there is this meta-narrative that appeals to identity and tradition, with much of the criticism, as you may know, focusing on the social understanding of the concept of gender that the convention, the Istanbul Convention, endorses indeed under Article 3, which is said or presented as a foreign imposition when the sexual binary and traditional gender roles accompanying it is being restated. And in Bulgaria, in fact, a decision by the Constitutional Court in 2018, with 8 judges signing that decision and 4 dissenting, held that the convention indeed, and this Article 3C, contradicted Bulgaria's constitution precisely on the basis of the social understanding of the concept of gender that the court thought was not compatible with the reference that the Bulgarian constitution contains to women as mothers and birth givers, when the Bulgarian constitution says that the state is to protect mothers and as birth givers. This is read as affirming gender roles and sexual binary, and therefore defeating a social or constructionist understanding of gender. So finally, I would like to raise 2 questions. One, in the hope that we can maybe discuss them further. One is the question as to whether there is, we can see, beyond the fear, I think that we all share, there's any hope to see what is going on as opportunity structures. I would say maybe potentially for 2 things. One is reviving feminism and or strengthening local feminism. There are many people who already think that the Me Too movements and the massive mobilization of women across the world are coining what will be in the future recognized as a new wave of feminism. And indeed, when I discuss these topics with my Polish or with my Hungarian and Turkish colleagues, many of them say that they are witnessing unprecedented levels of women's mobilization. And that, in fact, this is a challenge for reappropriation of feminist discourses, which so far often in the context of EU negotiations had been more like, imposed top down or very much further by, EU interventions. This said, I definitely don't want to undermine what is happening. And what is happening is that women's groups are being cut out of funding. What is happening is that civil society participatory mechanisms are being kept, but replaced by, people and societies that are friendly to the government's ideologies. What is happening is that the input is always sought from conservative think tanks. I'm thinking of all the Juris in Poland. And what is happening is that women are harassed, especially political activists, women's rights activists, and that misogynist discourse are being legitimized. So I don't want to sound naive. That said, there is fight back, as I said, and there's also interesting coalition between women's rights, human rights, and pro-democracy groups who see that this attack on women's rights is just part of a fight against, liberal values and human rights and democracy, more broadly speaking. And the second, question that I want to raise is whether maybe what is happening should give us food for thought. After all, constitutional tactics of one way or another can only work if they relied on wide, direct or indirect forms of popular support. They do require consensus and large majorities to mobilize and to operate. So I think it is important to understand what is helping, these governments and these movements retain their popularity to some extent. And I think that we really have to seriously consider the failures of neoliberal austerity policies as fueling the return to the national. In many European societies, for instance, several populist and far-right forces have supported governments which promised social assistance. I'm thinking of Turkey, Hungary, but also Poland, that through a protectionist, patriarchal lenses, promise to provide services to mothers and their families that they don't actually find in the market. And remember that they do so precisely in societies that where, people were used to relying on state protection and have experienced market freedoms as much less emancipatory than were promised. So we know best how to protect the family, and our women and children is a very enticing claim, and it's really not very different from the argument that is relied upon to reject the Istanbul Convention and its gender approach for the sake of older gender-neutral formulas to combat domestic violence, or for the sake of paternalistic and punitive means to do so, which unfortunately do not place emphasis on women's empowerment. In this context, I think there is a clear urgency to reclaim care and reproduction-centered societies and to revisit the ways in which neoliberal policies have undermined our welfare states, but maybe also to re-examine the patriarchal rules of the welfare states we inherited. I'm going back to history in the slide in which I go to second wave feminism, because I think that the images displayed remind us that political rights and even parity are great, but without guaranteeing women equal employment opportunities, but also tackling the sexual, reproductive, and care labor exploitation of women in the household, we cannot really go very far. And I think some of the mobilization and the resistance against women's advances is feeding on some of the frustration of policies that are being offered that do not really cater to the actual needs of many families and women. So to conclude, I think it is time to seriously think about the human dislocation provoked by globalization, the extractivism of neoliberal markets, seeing no limit to forms of human commodification, and undermining or impeding the development of strong welfare states. It is time to really, think through growing levels of inequality and its racialized forms, to think of the vertiginous digital revolution inevitably leaving many behind, and existential threats of the magnitude of irreversible environmental degradation and our pandemic. I think these realities certainly offer a scenario in which foundational social structures like the traditional family might appear handy to come to rescue of naked humanity, offering the protection of national anchoring, demographic survival, and an antidote to emasculation. I think the underlying conditions behind the generalized feeling of human anxiety must be addressed and societies reinvented, which provide enough security and hope for people to stop giving up on reproduction. The pauperization of motherhood and the global care chains, yet another form of unjust extraction, in most contexts also with clear colonial undertones, must be addressed. And together with the protection of the environment, we want to place the survival of the human species at the center of our political and economic organization systems. I think the time has come to give due visibility also to non-hegemonic and care-centered masculinities, and to challenge homo and transphobic prejudices around the need for and a capacity to care. I don't think we can expect that national retrenchments, a return to patriarchy, and the revisitations of old models of masculinity, not even in their generous, paternalistic, protectionist versions, and the persisting exploitation of women's productive and reproductive labor will provide the solution we need. Neither do I think we can leave things as they are and simply turn the gaze elsewhere. Thank you so much for your attention.
so much, Ruth, for drawing up this canvas that will allow us to reflect both in this coming roundtable, but also throughout the exchanges. So thank you so much. Please take the seat. And you will now be joined by two moderators for this session. So it is Marta Machado, you already met with Professor of Law at the University of Oslo, and also, until today at least, the co-director of LawTransform. And it is Lisa Hagedal, Professor of Political Science at the University of Bergen, and also a very core part of LawTransform. So I'll leave the floor to you.
Thanks, Ruth, for a wonderful lecture, and very timely lecture given what's been happening the last week in Afghanistan, amongst other places where we see a new backlash, arguably, against women's rights. But also, you're putting in a constitutional perspective and also focusing on what are the opportunity structures there, whether they're legal or political, for women and feminist organizations and other constituencies. Lisa, do you want
to? Hello, everyone. And again, thank you, Ruth. So Mal and I are we've been charged with sort of heading a conversation for the next 45 minutes. We have two more speakers who will comment on your presentations and who would sort of help lead us on into discussion. So everyone else listening in the audience, but also virtually, feel free to post questions and we will try to bring them in as soon as possible. I think it makes sense, but I think we will start by introducing the two new panelists, but yes, it is almost impossible not to reflect on what has been happening the last 48 hours in Afghanistan and, for what this does for this whole topic of today. So we probably will get back to that, but why don't we introduce our two virtual speakers? And do you want to go first and then I'll go second again?
Not sure we have Reva yet on Zoom.
Reva's not on Zoom yet?
Yeah.
No, she's not.
Oh, right. So then we'll introduce Marta.
Marta,
Marta, are you here?
Yeah.
Yes.
Who's Machado, who's a professor at the University of Sao Paulo. Has a background in philosophy and theory of law. Also Associate Dean for the Academic Master and PhD programs at the Center, and a researcher at the Center of Democracy and the Law of Law at Brazilian Center for Analysis and Planning. And she works on, well, pretty much everything. Obviously, the Brazilian feminist movement and campaigning for legislation on gender violence, but has also very much worked on criminal justice issues, human rights issues, the performance of the Brazilian courts. So, Marta, we look forward to your reflections on the election.
I'm not able to open the video. It says that the host stopped it. Hello, I can't open the video. Are you hearing me? But I'm unable to start the video. I think the host has to allow me to open the video.
Next year, we will all be here.
We said that last year.
I know, we said that last year too. We'll continue saying that until this happens. So,
the link is working fine, right? Because someone else told me they couldn't connect to the link, so I don't know. Oh.
So, what do you know what's going on? For me, it seems the host.
I can hear Marta on my computer.
Oh, Reva's writing. What is she saying?
It's a problem with the loudspeakers.
Okay, so
Marta,
you are here, but we are not able to hear you on the loudspeaker, so you're going to have to start again. Oh, I'm sorry.
I have to start again?
I'm not here yet, so.
No. But
I could put it through my laptop. Yeah, sure. Let's do that.
No, I need authorization to start the video. She's saying she needs authorization to start the video. Do we know?
Hi, are you hearing me?
I know.
You just need to be patient.
No.
This is what we have.
This will sort itself out. But
You guys writing, so.
Okay.
There's Marta. Hello,
There's Marta.
Marta. Oh, it's wonderful to see you. Hey, let's just, can we hear you?
Hi, how are you? I'm
No,
glad
we can see
Yeah,
you, but we
hear me?
cannot hear you.
you cannot hear me.
Yes, we can hear you.
It's on my
Hey.
computer.
Is that your computer?
It's my computer.
Hey, welcome.
I really wish I was there. Thank you so much for the opportunity to be talking to you even in a distance. I will just. So should I comment? Should I make my comments now on Ruth? Okay. So I was really, thank you, Ruth, for your really impressive talk. I'm really happy to be able to hear that and make sense of this global phenomenon, because I think I've been studying the Brazilian political process on abortion rights. And for me, it's really interesting to see how this global anti-gender repertoire that has been gestated after Cairo and has been diffused transnationally, how does it go through process of local adaptations? And in a local political process, it responds both to the general tendencies, but also to the local balances of political opportunities, to local concerns, local values and histories. So for me, it's really interesting to hear you and to see how the general trends are evolving and how can we relate to what is going on in Brazil. And from a national perspective, it's also interesting to see how the antecedents of what we are living now, how the pro-life movement or the pro-family movement, or what became the anti-gender movement, is the roots of an important constituency or an important basis of the Bolsonaro government, and which is also global phenomenon, but with very specific local features. So what I wanted to flag is that if we look to the Brazilian process with more longitudinal lens, we see that the backlash started, in fact, in 2006, and not, as many commentators mention, there's also a tendency to criticize the Supreme Court decisions. So we had some Supreme Court decisions, important Supreme Court decisions on abortion in Brazil in 2012. But if we look to the whole process, we see that actually the backlash started in 2006 after a real attempt on a progressive government to pass, in an alliance with progressive congressmen, to pass very progressive legislation that would not only decriminalize abortion, but also impose to the public health system to provide it, and to health insurance issues, to health insurance companies to cover it. So there was a moment that the pro-abortion movement almost got there, and it was prevented by a corruption scandal. Unfortunately, that was a coincidence, but that made the government, the weakening of the government, and then the government had to step back. And that was the trigger to the anti-abortion field to go through a total renewal of its strategies, its organization, its strategy frames, and etc. And that was the moment that the Brazilian anti-abortion movement connected, in fact, with this global tendency. So we had before a scene where the Catholic Church was the main actor, and the Catholic Church would mainly act through lobbying, through authorities. And from that moment on, 2006, there was the foundation of a Brazilian anti-abortion movement, a national anti-abortion movement, which would mean alliance between Catholic and evangelical churches, and evangelical and Christian politicians were getting really important in Brazil. So it was not only an alliance between churches, but also an alliance between NGOs, pro-life and pro-family NGOs, with a political branch formed by Christian politicians. They founded pro-abortion, anti-abortion, pro-life and pro-family caucuses. So there was a strong. They got really strong with this combination between societal mobilization and societal roots, and a very strong political branch. So that really mobilized the anti-abortion field. And we see here many trends of what you mentioned in your lecture, Ruth. So first we saw a variety of strategies coming up. So anti-abortion movements started to mimic progressive social movement strategies with annual marches, sittings, campaigns, litigations. They started to be very active in the Supreme Court, so presenting constitutional challenge, participating in public hearings, proposing amicus curiae. So there was a real intensification on different kinds of strategies, and a meaningful change in the frames, especially in the legal frames. So we saw also here changing, a decrease in religious sources and religious discourses, and more presence of science and law. We see here also the frame of gender ideology, gluing together different agendas, so different oppositions to rights, so women's rights, LGBT rights, then this new field of battles in school curriculum and gender education and sexual education got really strong. But also the shifts in the legal discourse are very interesting. So first, of course, we had right to life, reasoned in a religious way with religious source, so quoting the Pope and etc. And then we see more and more scientific arguments and legal arguments on the right to life. So, but also the right to life started to give path to protection to the personhood of the fetus. So we granting rights of personality to the fetus, but and going into the dignity divide. So dignity became a divide. So there was a huge amount of debates on dignity of women versus dignity of the fetus. But I think the most interesting features are when they start to use anti-discrimination, rights of the children, rights of people with disability, quoting international human rights, really stepping in and disputing very actively the human rights discourses, which is getting very strong when we enter the field of liberty rights or claims of conscience, as Siegal defines. So we have we had a very interesting constitution, a very interesting claim, conservative claim on against the Brazilian chapter of the Catholics for the right to choose, for example, and it was a constitutional case argued only in the mainly on the basis of religious freedom. So I think that's something also that you mentioned, and I wanted to stress how liberty frames or claims of conscience that we saw in the abortion fields, in the abortion field, when we saw implementing of abortion being trumped by doctors who would argue claims of conscience, but it expanded in a way that now we see freedom of conscience, freedom of speech, the moral freedom of a family to raise their children as according to their own values. So we have this interesting ways to use claims of freedom with a kind of anti-pluralistic vein. So I say it's with the sign or inverted. Another feature that is interesting in the Brazilian legal debate, that it also relates to what Ruth described, is the protection of women's health frame. And this is particularly interesting in Brazil because Brazilian pro-reproductive rights movement had a specificity of traditionally not using individual rights frame. So autonomy, intimacy, privacy was not the main frames. They were very residual. They appeared most in court cases, but the Brazilian pro-reproductive rights movement was really using health frames. This is because the Brazilian movement was founded as an alliance between feminists and public health activists. The Brazilian in the Brazilian democratic constitution, health is a central issue. It's a constitution that has a social feature and claims of substantial equality, claims of full citizenship, and health was very important at the moment. So the Brazilian I don't even call Brazilian pro-choice movement, because it's not, choice is not a native category of our movement. I try to adapt, and I say Brazilian pro-reproductive rights or pro-reproductive health movement, because health was in the center of the movement. So what's interesting now is the strength that protection of women's health is used by Brazilian anti-abortion movements, trying to neutralize the health frame. So of course it's interesting to see how they mobilize different. So to protect, it's paternalistic, because women have to be protected from the trauma of the abortion procedure. We protect women's health basically by enforcing criminalization, and there is absolutely no talk on public health. So that's a huge difference of how health rights is being reshaped by the conservatives. So it was mostly mobilized from the point of view of public policies, comprehensive public policies for women, expansion of public services, expansion of access, special programs for special vulnerable groups of women. That was how we advanced. That was how the pro-reproductive rights movement advanced, mainly through health public policies, and now health is being disputed in a very individualistic way. So I wanted to mention that, because I think that's one of the features of the dispute around rights. I think individual rights. It's not a coincidence that the individual rights are being mobilized. The right to health is being disputed to be understood in the individual terms and not as a collective good. And these types of claims of liberty also with a strong emphasis on individual rights. So I think this is also meaningful. It explains a lot the alliance between the neoconservatives and neoliberal forces, and the protection of the family unit as being the empowerment of the family unit as opposing to state offering public services. So I think there is something here to be disentangled in between this alliance between neoconservative and neoliberalism. And I also wanted to mention how they got more sophisticated and the role of lawyers association. I think this is new. We have in Brazil, they are very central in anti-abortion forces in Brazil right now. Lawyers associations, we have lawyers think tanks and lawyers associations like Lawyers for Life. We have one very important one, which is the Evangelical Law Association of the Association of Evangelical Lawyers. They are becoming central in the battle. I wanted just to give just to talk a little bit about this special association. They use the legal claims are getting sophisticated, so it's and use it very strategically. So separation of powers is appearing here also very strategically. When the Supreme Court is going to decide something in favor of LGBT rights or women's rights, the claim is the Supreme Court or the elite judges are stealing the power of the parliament. So this is not the local. So they also try to avoid the moral battle to say, I'm not talking about the substance here. I'm talking about the right place to decide. And the Supreme Court is not the right place to decide. It's an elite power stealing the power of the people and so the Congress should be deciding about that. That's very strategic because of course the Congress, especially after 2018, is getting more and more conservative, but it's very contradictory also with what they are making because they are litigating more and more. So it's also interesting to see this type of contradictions. And I'm just making this last point and I'll close. I understand that the conservatives entered the dispute and they are using all the tools that are at their disposition in a democracy. So it's also a fruit of democracy that we see conservative forces trying to frame their views in the language of rights. So we could also see this phenomenon as a strengthening of the rule of law because they are not anymore arguing on the basis of on religious basis, but they are trying to use human rights. They are trying to use institutional language. On the other side, there is a basic contradiction in their discourse because they enter the legal game. So they enter the legal dispute. So they are disputing the language of law, but while they do so, they say, they affirm their view are the only one. They have absolute views about their position. So my view is the only one that is right. That comes from this type of natural law reasoning that cannot be accommodated with women's rights or with other rights. So I think there is something contradictory in this movement that I enter the dispute, I enter the political dispute, but I also say that I have absolute views about the dispute. So my view is the only correct view. And the other contradiction is, of course, using liberty rights to or freedom of religion, which is, of course, it has a pluralistic view in in the total opposed direction. So the example of the Catholic for the right to choose, I use freedom of liberty to stop one interpretation of the Catholic doctrine. So I think there is a challenge for legal scholars here to understand, not to block, I think our challenge is not to block from the entrance the fact that rights can be disputed and can be shaped in different directions, but try to understand, so what are the consequences of this certain interpretation of rights? So I think it's a similar task that we have to understand populist movements, because they are a phenomenon of democracy, but they are also eroding democracy. And I think we can see a parallel here, because we see the disputes over law by the conservatives. It's also a phenomenon of democracy, but they are also eroding democracy and rule of law when they have anti-pluralistic views, absolute views, and views that don't accommodate other groups' rights, and mainly harm other groups. So I think this is something to be discussed and maybe to be further developed for legal scholars. How can we make sense of this type of uses of human rights and liberty rights?
Thank you so much, Martha. We really, really, really appreciated this. And this is difficult to have a kind of a conversation where some of us are here, you are somewhere else. And I'm just now aware that our third speaker will not be able to join us. So we will not be able to hear Reva Siegal's perspective, which gives us we still have 20 minutes, and there is space for you to ask questions and also on the chat. But I don't know, maybe Ruth and I, there is a question already that I didn't see. No, sorry. But I have a question.
Oh,
This is Ruth, I did my slide before you guys. So what I was thinking is, like, I think your presentations have really, and I think your perspective, Martha, you really sort of perspectivized Ruth's plenary lecture with the Brazilian perspective. And then I'm just thinking, maybe I just want to turn this around and back to your starting point and end point, because both of you have given us a very vivid explanation of what I would call a backlash, a sort of gendered and democratic, a gendered backlash that is sort of in a context of them, in the Brazilian case, a democratic backlash. On the other hand, and Martha, you very, very clearly showed us how the opponents of women's rights are using maybe this tactics and lessons from the women's rights movement. And so my question is, what do we have? Like, okay, what have we learned? So, okay, there is a backlash, but what have we learned along the way? So what, like, from previous battles, and how can we sort of use our lesson not to make sure that we're sort of back in square one? So the question to me, I wanted to reflect on, is this a total backlash, or are we sort of starting on a different level with a different sort of level of knowledge? So maybe you can just reflect sort of, to me, it's hard not to think about this question, in the case of Afghanistan right now, right? What do these 20 years mean? Is there anything at all? So I thought if you feel like it, you can answer more generally, or you could bring in the Afghanistan case. So I just really want to pose this question to you both. Are we kind of back in square one, or have we learned something?
I don't know whether I'm responding to what you're asking, but I'm responding to the core that your question raises in me. And I would say two things. I mean, I think, so the basic contention of the lecture is that this gendered order was actually foundational to the modern constitutional democracy. So it's an irony because we're saying it's a backlash, but actually it was in the DNA of our societies. I mean, it's wonderful to read some of the early case law in, post-World War II constitutionalism, where you see the German constitutional court and the Italian constitutional courts totally reaffirming the breadwinner family model. It was the highlight of the breadwinner, historically speaking, the post-war years. So in a way, and this is also what makes it so easy for these movements to play around this, because in a way, what we have been witnessing, I think, over the last, I would say, since the mid-90s, is what I think, and that's the main thesis in my book, is how there's a new constitutionalism that disestablishes, that challenges the foundational gender order that wasn't challenged at the foundation of the modern liberal democratic state. So there's a way in which you could say what is happening is simply reclaiming the good old values of liberal democratic constitutionalism, and not going before medieval obscure ages. It's actually reclaiming the DNA. So of course, because that DNA has been challenged and eroded over the last 30 years, in that sense, we experience a backlash. But think of how interesting of what Marta was saying, how what are being reclaimed are spaces of autonomy that have been constitutionally protected. The family privacy, the freedom of how you run your business, entrepreneurial freedom, freedom of political parties, freedom of the press. These have been constitutionally protected spaces. Now, recently, they have been challenged, and we will discuss that in next panel. Gender quotas, parity, they have been challenged. So part of the feminist reading of constitutionalism has been to say it's not enough to think of state protections. What we need is to democratize and set an equality ethics in every domain of human interaction where power dynamics can replicate, whether they be public or private. But that is a huge departure from the foundational constitutional order that did carve out those spaces of autonomy, right? So I think that in a way, it is a backlash if you consider some of the new milestones that were being achieved and fought for, but it is very easily, coded and dressed in good old constitutional doctrine, because in fact, that was the constitutional doctrine for many, many, many years. So I don't know whether that touches. My other, this goes from a very different perspective, is that my fear of anxiety is, what have we learned that we wouldn't want to replicate? This goes to a different direction. But I would say, what we have learned that we don't want to replicate is the price the feminist movement has paid historically for internal divisiveness. And I understand that, second wave feminisms and mainstream liberal feminisms has always of shortcomings, and that, the intersectional, racial, colonial elements have to rightly come to the fore. But I'm mentioning that. I watch in my country how the feminist movement is hugely divided around the question of intersex and trans rights. If I say, is there something we should have learned? I would say we should set our priority order straight. And in light of so much contestation to the basic foundation of some of these things, I think we should really be careful not to fall in the trap of prioritizing some of these issues which are central, but where do we want to put our energies? Do we want to put our energies in fighting against self-definition when it comes to womanhood, or do we want to put our energies in resisting and fighting back these huge global counter movement. I think that is the one thing I would hope that, you know, the feminist movement would have learned by now. I'm doubtful that, you know, we keep repeating the same mistakes, but I think we're playing the game. I think these internal divisions are legitimate, but I think someone else is having the day of their lives when they see the movement internally divided and they can move on with their, and they say, you know, see, you see, especially because some of the debates really, you know, the connections are obvious, right? These movements reaffirming the sexual binary, and so are feminist strands that are, you know, fighting against self-definition. So, you know, some of the, you know, strange bedfellows in some of these conversations, I think, are a reason to worry. So two very different answers, but they were both provoked by your question.
Thanks very much. I actually have a little question myself.
That's what I was thinking, and then Martha will come in and
okay.
yeah. I need to give you space too.
Yeah, okay. So it's about opportunity structures and the extent to which one can generalize about what the feminist and women's movement needs. I mean, in some countries, maybe the legal opportunity structure is more open. In some countries, the political opportunity structure may be more open. In some countries, neither is more open. And in some countries, as you indicated, it's more top-down backlash. In other places, it's more bottom-up backlash. And also Marta's comment raises, you know, questions around strategic approaches. So you indicated at the end of your lecture, you know, re-emphasizing the feminist agenda. You've also talked politically about, you know, unifying the feminist movement. But what about other constituencies? To what extent should one be making allies? Okay, so make an ally with the health movement, and you talk about health rather than choice. But that also, you know, creates other risks. But is that the way to actually get political traction if you're on the back foot? So I'm just really interested to what extent one can generalize about needed political action, to what extent it's really a matter of context, or there's some conditions we can talk about. In democratic context, you can do this. In rights-rich context, you can do this. You know, go back to Afghanistan, and what the women are actually asking now, what opportunity structures do we have? How do we navigate this? And you're seeing already female journalists and activists in Afghanistan discussing, you know, to what extent to engage, resist, flee.
I share your same concerns, and I really don't think there is. I think it is contextual. What was interesting about Marta's reference to health, the health framing, is that it's interesting that for a long time it allowed, you know, progress in reproductive rights to fly under the radar. We were talking about health. We were not talking about autonomy. It's much more threatening when women assert autonomy of their own bodies and destinies than when we're still holding on to the health frame. After all, you know, we can say women need their health protected. So it falls very nicely into the victimhood protectionist framework that is the traditional patriarchal framework. At the same time, of course, why not? If Brazil has, you know, a strong social rights framing in their constitution, you would obviously think of making use of that. So I think it's contextual, but I think it's interesting how these things can then backfire, right? Because you put all your eggs on health, now you're kind of allowing that health frame, and you don't have a strong autonomy or equality narrative or doctrine to rely on. So it's just, and you can't foresee these things because, you know, you act now for what's going to happen. So I think it's largely contextual. But for me, the one lesson to draw is probably one of priorities, and I think parity should be a clear priority. So I think that in view of this, if there's one item we should definitely foreground is that women occupy half of the power in every side of decision making, so that whether you're talking about civil society power or legislative power or judicial power, you're still talking about, you know, female power. So that would be, you know, I think it's contextual. I don't think you can generalize. I mean, I'm thinking of Spain now. We have had We have had an abortion law that has been allowing women to have an abortion since 2014 without an indication system in the first 14 weeks. And it had been challenged by the conservatives. The Constitutional Court kept not wanting to resolve the issue, among other things, because the right-wing forces had been in government and hadn't changed the law. And now, a few civil society activists are going to Strasbourg and saying, the court should decide. And now suddenly we have a conservative court, which, 10 years after may turn down in spite of A, clearly societal consensus, and B, the political forces behind, the restrictive reading now not wanting to pay the political price of having that battle. And it may be that because of pressure exercised by the European Court, simply a procedural grounds, the court now, decides this issue. Top it with the fact that it should have been renewed and it hasn't been renewed. And that is what accounts for the conservative majority sitting in it. I mean, how contextual and random can that be? So I think it's contextual, but I think the other lesson is whatever it is, we want women in power so that whoever exercises the power of its forces are included.
You want to come in, Marta?
And I've also just a note, I've got a
Yeah.
question also from Karimetta on
Yeah.
Zoom, which I'll also want to
Okay,
squeeze
so
in.
do we have some
Quickly from Marta.
super quick response from you, Marta, and then we have one question. And we have
Okay,
5 minutes left.
One comment on what Ruth just said, that it's important that we do this kind of reflexive movement of thinking about the paradox or the ambivalences of our strategies. I think it's what we have. I think it's our task now to think about liberal rights frame or human rights or individual rights frame, how it allowed us to advance in some instance, but it also has ambivalence and be easily disputed. I think that's the issue also for the health rights. I think it has, as it has been addressed in Brazil, it has an equality issue involved. It has been always discussed together with equality of offering public services for everyone, but health can also be disputed and interpreted in individual way. So I think it's time for us, and it's something that I've been writing with Thais Penteado, which is in fact a former Bergen Exchange PhD, but also a PhD in FGV, on the opportunity that the pandemic opened for us to use or to strengthen, not to strengthen because it has not been used in the Brazilian setting, but to use equality to fight, to discuss reproductive rights. I think the pandemic was, it stressed so much the condition of women and the burden of reproductive rights, of the reproductive work, the solo women that had triple shifts, mainly black women with impairment in their house, with no internet, with a lot of problems. So and unemployment of course hit women mostly. They were mostly employed in the service sector. They were most informal. So I think the pandemic stressed so much. In Brazil, we say that we retrogressed 3 decades in terms of women equality. And in that situation, I think that's an opportunity that's tragic, but it's also an opportunity that would bring reproductive rights as in equality frames, in substantive equality frames. And that's also interesting in the Brazilian context, because since we have a constitution that has social rights and allow us for using substantive equality reasoning, why not to do that now? So I think that's an important moment, as Ruth mentioned, that we can figure out how our strategic moves in the past allow us to advance, but also backfired, or they are provoked ambivalent results, or our resources are now being disputed by the other side. And we do have huge equality issues to address. So I think I would say that that would be the direction we think we should think, the direction we should think now on reproductive rights, approaching to idea of reproductive.
Marta, we just have to cut you off there because we've just got 1 minute left.
And we have one question. But the good thing in Marta is that we have a whole week and then we're going to have many more discussions. And this is fantastic. I love listening to you. But for
It's an interesting, provocative last question, which Ruth can take perhaps as concluding comment.
for 30 seconds or something?
Yeah. Both presenters demonstrated how contested different conceptualizations of human rights are in different countries. Do you have any comments on the degree to which the legitimacy of human rights altogether can be sustained in light of such differences? Can we talk about gender and human rights if it is so contested throughout the world?
And you want me to answer that in 30 seconds?
Yes, 30 seconds.
It's an excellent question. Thank you.
I would say I understand where the question is coming from. My fear is I don't quite see that we have a strong enough alternative to totally dismantle human rights. So I am on the camp on let's revisit human rights, specifically the domain. It's not that we didn't have an equality tradition. It's the domain of human rights. It's the public-private division that somehow keeps on there. That is, I think, what we should challenge. So it's not just, it's the domain of application of human rights. So let's reinvent many of the defining features of human rights, but let's not give up on human rights altogether because, what is the alternative then? It's not very clear to me. The market doesn't quite seem to do it. And politics is politics, and it can help you one day, but it doesn't the day after. 2018 was the turning point in Brazil between two very different political scenarios. 30 seconds, more or less.
Amazing.
Very good, Ruth.
Very, very good. Thank you both. There is a French fantastic author called Annie Arnaud, and she says, there's climate change. The world is burning up. And I could add, and then there is Afghanistan. But at the end of the day, the question is, what am I going to make for dinner? And I think this sounds like a joke, but it's serious. First of all, we need a break. We need coffee. We have a new session. But also, I just want to iterate what you're saying. We cannot, we actually do have to sort of keep our priorities straight. And we have to, when things, in this situation, it is just super important to do exactly as you said, make priorities. And I think that would be my sort of concluding comments. Thank you both very much. We will be continuing this amazing conversation throughout the week. So this was just the start. And I miss you, Marta. I miss you.